From December 2025, the question in the UK won't just be, do you have a visa, but are you still allowed to stay at all? New deportation rules mean that a criminal record, a broken visa condition, weak English, unpaid taxes, or even the wrong passport at the wrong time could push someone onto a removal list. People with jobs, mortgages, partners, and children may suddenly discover their status is no longer secure. If you or someone you love lives in the UK, you need to understand exactly who could be forced to leave under these changes before everything changes. Number 1. Foreign nationals with criminal convictions will face immediate deportation. The first rule focuses on foreign nationals who receive criminal convictions in the UK, even if the offence is not considered serious by older standards. Under the new system, the Home Office will have expanded powers to trigger automatic deportation procedures once a conviction is recorded and sentencing begins. This applies to a wider list of crimes than before, including offences related to fraud, organised theft, cybercrime, violent conduct, and repeated antisocial behaviour. The government's aim is to fast-track removals of individuals who are judged to pose a risk to public safety or disrupt community environments, closing loopholes that previously allowed convicted offenders to remain in the country during lengthy appeals. This rule will also operate under the Deport Now, Appeal Later framework, meaning that many convicted foreign nationals will no longer remain inside the UK while challenging their deportation. Appeals may continue from outside the country through legal representation, but the physical right to stay during the challenge will be removed for most affected individuals. Furthermore, a wider list of countries will fall under the safe return category, reducing barriers that once blocked deportation on human rights grounds. The government believes this approach strengthens efficiency and protects resources, especially in prisons and rehabilitation services. For residents with non-UK citizenship, this section highlights the importance of maintaining full legal compliance, tax records, and community responsibility. Any criminal conviction has the potential to trigger immigration assessment and removal, even after many years of residency. Migrants who are currently navigating the legal system or facing charges should ensure that they have proper legal support, as timely guidance can affect long-term outcomes under the new policy. The government has made it clear that criminal activity and immigration status will be more closely linked than ever before under the 2025 rules. Number 2. Stricter suitability framework for long-term residency and settlement. The second rule introduces a far tougher suitability assessment for migrants applying for long-term residency or settlement in the UK. Previously, the system mainly checked criminal records and immigration history, but under the new framework, a much deeper evaluation will take place. This will include behaviour in public life, consistency in tax filings, financial reliability, record of employment, civic responsibility, and compliance with UK laws and regulations. Even individuals who have lived in the UK for several years could face refusal if they fail to demonstrate a stable, responsible, and law-abiding lifestyle. The government states that settlement must now be earned through conduct and contribution, not simply time spent living in the country. This suitability test will become a key deciding factor before granting indefinite leave to remain, affecting those on work visas, family visas, study routes transitioning to work, refugee routes, and other legal pathways. The new test also aims to reduce the number of people obtaining settlement through weak supporting evidence or minimal community participation. Behavioural patterns such as repeated fines, unpaid taxes, benefit misuse, unresolved debts, and public disorder may now count as negative suitability indicators. Even short-term mistakes that were overlooked before might now influence immigration decisions more directly. The government believes this approach raises standards for long-term integration and strengthens the value of UK residency. Migrants planning to remain in the UK permanently are advised to focus on compliance, documentation, and community presence. Employment stability, proof of address, consistent tax history, volunteering records, English language progress, and professional development will serve as positive markers during the assessment. Practical steps such as maintaining clean records, paying bills on time, updating visa information promptly, and staying engaged in lawful activity will matter more than ever. The overall message behind this rule is clear. Settlement is no longer automatic after time spent in the UK. It must be continuously justified through responsible behaviour. Number 3. Longer qualifying period for indefinite leave to remain, ILR, under the new earned settlement model. The third rule signals one of the biggest shifts in UK immigration policy, as the qualifying period for indefinite leave to remain, ILR, is expected to extend from the current 5-year requirement to 10 years for most visa categories. This change represents a move toward what the government calls an earned settlement system, meaning long-term residents will no longer be based primarily on time spent in the UK, but on sustained contribution and compliance. Migrants who are preparing to apply for settlement soon may find themselves needing 5 additional years of lawful residence, continued employment, strong immigration history, and consistent visa renewal without gaps. This longer period is designed to ensure that only individuals who remain productive and law-abiding over a decade will secure permanent status. The extended qualification timeline will affect multiple visa routes, including skilled workers, family visas, health and care workers, graduate route transitions, entrepreneurs, and most humanitarian or private life applicants. The objective is to encourage deeper integration into society, not just temporary participation. People who move frequently between visa routes, experience unemployment without valid explanation, or rely heavily on public funds may face delays when approaching settlement. The government has emphasised that this longer monitoring period will help verify whether an applicant continues to contribute positively across several years, rather than only in the months before applying, which was a common criticism of the old system. The new structure will also increase the importance of clean immigration records, timely renewals, and continuous proof of residence. Migrants who wish to secure ILR under the upcoming rules should begin preparing early by collecting employment documents, tax history, proof of stable address, language progress records, and evidence of community links. Applying for settlement before the new system fully activates could shorten the wait if eligibility is already met. Those who cannot apply yet may benefit from reviewing long-term planning strategies with their employer or legal advisor. Maintaining job stability, avoiding visa gaps, and demonstrating ongoing social and economic participation will become essential stepping stones to reaching permanent residency under the 10-year requirement. Number 4. Higher deportation risk for overstayers and undocumented migrants. The fourth rule targets individuals living in the UK without valid immigration status, including overstayers whose visas expired and undocumented migrants who entered without legal permission. Under the new legislation, the Home Office will prioritise removal of anyone who cannot show lawful right to remain, regardless of how long they have been in the country. The policy removes several protection barriers that previously slowed down returns, and it places overstaying on the same behavioural scale as criminal non-compliance. Even people who have built long-term lives in the UK without valid paperwork may face accelerated deportation if they cannot provide evidence of an active immigration route. This reflects the government's focus on reducing irregular migration and tightening border control standards across all regions. There will be a significant expansion of immigration enforcement activities, including greater use of real-time data sharing between government departments such as HMRC, DVLA, NHS, banks, and local councils. Access to services such as renting property, opening bank accounts, employment checks, and benefit access will become even more dependent on real-time immigration verification. Undocumented migrants who previously lived without administrative detection will likely encounter increased monitoring, leading to immediate notifications to removal teams. The government states that its goal is to discourage informal residence, overstaying after visa expiry, and avoiding immigration procedures. People who knowingly ignore visa rules or remain undocumented will no longer have broad appeal protections to delay removal for long periods. Migrants whose visas are close to expiry should act early to avoid falling into the high-risk category identified by this rule. Options such as extending a visa, switching routes legally, seeking skilled sponsorship, apply on family or private life grounds, or requesting humanitarian consideration may prevent major complications. Those already undocumented should seek legal advice immediately rather than waiting for enforcement contact. Any delay increases the probability of arrest, detention, and enforced removal under the 2025 framework. The overall message is that lawful status must be maintained continuously, and relying on time spent living quietly in the UK will no longer provide any protection from deportation. Number 5. Total ban on asylum and settlement through individuals convicted of sexual offences. The fifth rule introduces a zero-tolerance approach toward migrants who have been convicted of sexual offences, even if the sentence was short, suspended, or served many years ago. Under the new policy, anyone who appears on the UK Sex Offenders Register or has been convicted of crimes such as sexual harassment, exploitation, assault, or possession of illegal explicit material will automatically lose eligibility for asylum, humanitarian protection, or future settlement. This applies even if the individual originally claimed asylum on the grounds of persecution. The government states that national safety takes priority, and that asylum cannot serve as a shield for individuals responsible for high-risk offences. The legal message is strict and unambiguous. Safety concerns outweigh personal immigration circumstances or historical timelines. This new rule also affects migrants who already live in the UK with temporary permission. Even if someone has remained in the country legally for years and has family ties, home ownership, or employment, any past sexual offence on record can trigger immediate deportation once reviewed. The Home Office is building a dedicated system to cross-check asylum and immigration files against criminal records, meaning no conviction will go unnoticed during future reassessments. People whose past sexual crimes were previously overlooked in immigration decisions could now be re-evaluated. Those who completed rehabilitation programs or served their full sentence will not receive exceptions, as the updated legislation focuses on public safeguarding rather than punishment. Criminal rehabilitation does not create immigration forgiveness under this rule. Migrants who have unresolved or ongoing legal cases involving sexual allegations should be aware that immigration status now depends heavily on the outcome. Legal support is essential at early stages because a conviction will permanently block both settlement and asylum options. Family members connected to the offender will not automatically face removal, but sponsorship routes may be blocked if the applicant is ineligible. The government aims to deliver a clear national stance. Sexual crimes and long-term residence in the UK are no longer compatible in any circumstance under the upcoming 2025 framework. Number 6. Expansion of the deport now, appeal later system. The 6th rule drastically expands the deport now, appeal later model, which allows the UK government to remove a migrant from the country before their legal appeal is heard. Under previous rules, only a limited number of criminal cases qualified for this fast-track removal. But the new policy broadens eligibility to include a much larger group of migrants who are considered unsuitable to remain while legal disputes are ongoing. This means that individuals no longer have a guaranteed right to stay in the UK during their appeal process. Once a removal order is issued, deportation can occur immediately, and the person will then continue their appeal from abroad instead of remaining inside the country. The Home Office claims this reform reduces delays and prevents individuals from using the appeal period as a way to extend their stay unlawfully. The updated system introduces a wider list of countries classified as safe for immediate return, which significantly reduces the ability to challenge deportation on human rights or risk-based arguments. Even if someone believes that removal will affect their family life, employment, or personal welfare, these claims will not automatically suspend deportation unless considered an urgent exception by the court. Appeals will still exist, but the timing and location are shifting, and migrants will lose the advantage of remaining in the UK to gather evidence, seek representation, or attend hearings in person. The new policy reflects the government's intention to ensure that removal takes priority over protracted litigation, especially in cases where the Home Office considers the individual a threat or an immigration non-compliant resident. Migrants who are involved in legal appeals or are planning to challenge visa refusals must prepare thoroughly and promptly under this framework. Collecting documentation early, maintaining communication with legal advisors, and ensuring that case details are organized from the beginning will be critical, because once a deportation order is issued, access to in-person support becomes limited. Anyone who risks falling into categories connected to criminal behavior, repeated overstay, or breaches of immigration conditions should take the possibility of immediate removal seriously. The new rule establishes a firm approach. Appeals will no longer delay deportation except in a very narrow set of circumstances recognized by the court. Number 7. Tougher English language and integration requirements linked to immigration status. The 7th rule introduces enhanced English language and social integration standards as major factors in determining long-term residency and future settlement. Under the new policy, migrants will need to demonstrate not only functional language ability, but also clear evidence of integration into UK society. This includes participation in work life, education, community involvement, and consistent interaction in English. Applicants who cannot meet the new benchmarks may face delays, refusals, or even risk removal if their visa category relies on proven integration. The aim is to ensure that people living in the UK over the long term are active contributors who can communicate effectively in daily and professional environments. Reliance on translators, absence from community participation, and weak language progress over time could now influence immigration outcomes. The updated requirements will apply across multiple immigration categories, including skilled worker visas, health and care visas, family visas, extensions, settlement applications, and naturalization planning. Language tests are expected to become more challenging, moving beyond basic conversation to include listening, writing, and comprehension elements. Evidence of integration may include involvement in local organisations, voluntary activities, registered employment, participation in children's schooling, or other community-linked responsibilities. Migrants who renew visas without showing improvement in language skills may find their applications reviewed under the suitability criteria. The government has stated that integration is now considered a responsibility rather than an optional personal choice. This change also aims to prevent long-term isolation within linguistic or cultural bubbles. Migrants preparing for long-term residence should begin documenting integration efforts and improving English language proficiency as early as possible. Completing verified English courses, collecting certificates, joining community groups, engaging in professional development, and maintaining long-term employment records will build positive evidence. Parents supporting children's school involvement and adults contributing to local organisations can highlight these roles during applications. Even small, consistent steps matter because the new framework evaluates progress rather than one-time effort. Individuals who postpone language learning or ignore integration expectations risk falling behind under the 2025 rules, as the system makes it clear that successful residency depends not only on living in the UK, but on actively becoming part of UK society. Number 8. Visa and settlement risk linked to countries that do not accept deportees. The 8th rule introduces a major shift by linking a migrant's future visa approval, renewal, or settlement to how their home country cooperates with UK deportation policies. If a country refuses to take back its nationals who are ordered to be removed from the UK, the Home Office may restrict or block visas for applicants from that country. This includes work visas, visitor visas, study visas, and even family visas. The government argues that too many individuals remain in the UK because their home nations delay or avoid issuing travel documents for return, which obstructs the enforcement of immigration decisions. As a result, migrants from countries with low cooperation rates now face an added risk, regardless of their personal conduct or legal history. The new rule may also affect individuals who are already living lawfully in the UK. When the Home Office evaluates visa extensions or settlement applications, applicants from non-cooperative countries may receive extra scrutiny and longer processing periods. Immigration authorities will assess whether there is a realistic prospect of removal if the applicant later becomes unlawfully resident. If cooperation between governments remains weak, visas may be discontinued for new applicants or restricted to limited categories. This approach moves immigration control beyond individual behaviour and into the realm of foreign policy agreements, which places certain nationalities in a more vulnerable position, even when they are contributing positively to the UK economy and society. Migrants from countries with uncertain diplomatic cooperation should monitor updates about their nationality category and respond early, rather than waiting for restrictions to take effect. Securing strong employment records, sponsorship support, verified addresses, and long-term tax history can help reinforce applications when scrutiny rises. Those planning to apply for renewal or settlement in the coming months may benefit from doing so before policy conditions tighten further. The message behind this rule is that national cooperation with deportation policies now plays a direct role in shaping the immigration future of the citizens of that country living in the UK. And this factor will strongly influence decisions from 2025 onward. Number 9. Restricted use of family life and private life claims to prevent deportation. The 9th rule places tight limitations on human rights-based claims, especially those involving Article 8 of the European Convention on Human Rights, which protects family and private life. Under the old framework, migrants facing deportation could often delay or overturn removal by demonstrating that their close family members lived in the UK or that they had developed strong personal ties over time. The updated rules narrow these protections and require much stronger evidence before such claims can pause or cancel deportation. Living with a partner or having children in the UK will no longer automatically prevent removal, unless the situation meets strict hardship criteria. The government has stated that immigration enforcement should not be weakened by claims that are easily made but difficult to prove. The new standard demands measurable evidence showing that deportation would cause exceptional and irreversible harm to a family member, especially a child. This is a far higher bar than the previous system, which considered emotional impact, relationship stability, and school life among its broader assessments. The Home Office now expects families to demonstrate extraordinary dependency rather than normal emotional bonds. The shift reduces the influence of family-based arguments in immigration disputes and increases the likelihood that deportation will proceed whenever public interest or suitability concerns outweigh family connections. The government also aims to prevent situations where a parent or partner with an irregular immigration history avoids removal simply by forming a household in the UK. Migrants who depend on family life or private life grounds should begin collecting strong and verifiable evidence, such as medical records, statements from professionals, school documentation, and proof of exceptional reliance between relatives. Legal representatives can help determine whether a case meets the new threshold, or whether an alternative immigration route provides a safer path. Waiting until enforcement begins increases the risk of removal, because appeals will not always delay deportation under the new rules. The overall direction of this policy is clear. Family ties alone will not automatically protect individuals from deportation, unless the situation meets very narrowly defined hardship criteria. Number 10. Wider grounds for unsuitability, refusal, and deportation. The 10th rule expands the list of behaviours and circumstances that can make a migrant unsuitable to remain in the UK, even without a criminal conviction. The Home Office will assess suitability through a broader lens that includes behaviour linked to public safety, national security, repeated non-compliance with immigration conditions, financial misconduct, and involvement in activities considered harmful to the community. Under this rule, a person could face deportation or visa refusal if they are repeatedly fined for unlawful work, have a history of avoiding taxes, commit benefit fraud, engage in violent protests, support extremist organizations, or show patterns of behavior that raise security concerns. The government aims to remove individuals whose actions undermine social stability, even if those actions are not serious enough to result in a prison sentence. This rule also gives immigration officers the power to review past conduct when making decisions about future stay. A migrant who has repeatedly broken work restrictions, switched addresses without reporting, worked cash in hand illegally, or provided misleading information on applications may be flagged as unsuitable for continued residence. Some cases will be subject to special evaluation when financial risk is identified, such as large outstanding debts, suspicious income movements, or multiple cases of non-compliance with official reporting duties. The government states that responsible migrants who follow the rules will not be affected, while those who use legal loopholes or exploit the system will be prioritized for removal. Suitability is now based on patterns, meaning repeated small violations can collectively trigger refusal. Migrants who plan to stay in the UK long-term should focus on strict compliance and clean administrative records. Accurate visa information, reported residential changes, transparent income, correct tax payments, and lawful employment history Build positive suitability profiles over time. Anyone unsure about their immigration responsibilities should seek clarification before making decisions that could put their status at risk. Failing to correct paperwork or ignoring repeated warnings can now carry significant immigration consequences. The clear message behind this rule is that permanent residence will depend not only on avoiding crime, but on demonstrating ongoing responsibility, accountability, and respect for UK systems and regulations. The new deportation rules, coming into effect from December 2025, signal a dramatic shift in how the UK handles long-term immigration. Residency will no longer depend only on visas, years in the country, or family ties. It will depend on conduct, contribution, and compliance. People who once believed their status was secure may now face re-evaluation under stricter criteria that combine criminal history, financial records, language progress, integration, and cooperation between governments. Deportation is shifting from a slow, appeal-based process to a fast, enforcement-first model, where removal comes before legal challenge. For many migrants, stability in the UK will now depend on preparation rather than assumption. Those who plan to build a future in Britain should stay informed, maintain strong documentation, and avoid delays in resolving visa or legal issues. Seeking professional advice early will matter more than waiting until rules become active. Understanding the system is now the strongest form of protection. If this video helped you, make sure to like the video, subscribe to the channel, and share your thoughts in the comments. Tell us which rule surprised you the most, and whether you want a full breakdown of visa categories under the new 2025 system. Stay tuned for more updates that can protect your future in the UK.